Can I read that on behalf of Mr. Murray, who is approaching? Can you please say your name for the record?
Carl Murray.
Your Honor, we're asking for an adjournment. He does have a PCC on another case on the 22nd. We would love to resolve them together, so if we can have an adjournment to that date.
5 days out.
Yeah, I've already reviewed the discovery on this case. I just need to do it on the other case.
2025. 9 a.m. File continued.
Thank you.
Okay. Court calls case People versus Thomas Lee Ellis.
And Lord Yagi, Assistant Public Defender, with and on behalf of Ms. Ellis, who's approaching.
Your name, sir?
Sorry right now. Thomas Ellis.
Okay.
Your Honor, we are asking for another adjournment. Mr. Ellis did do the screening and assessment for 14B, but we need a follow-up letter from his doctor. So we're asking for an adjournment for that reason. He's going to see his doctor today. So.
Probable cause conference without objection, August 7th, 2025, 9 a.m.
August 7th. Thank you, Your Honor.
Court calls case People versus Sean Newton.
Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender. Go ahead and state your name. Sean Newton.
Thank you.
Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral for drug court.
Okay.
Oh, I'm sorry, no, I'm drug court. Yeah, actually, I'm confused. I need somebody. No. We're gonna waive this matter over.
You're gonna waive?
I'm looking right at the waiver right now.
Sir, you're gonna waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir. I'm trying to plead guilty at circuit court and get out of here.
That's too much information.
All right.
Bond reduction note, Your Honor.
Where I got.
Okay.
I'll do that.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution.
Absolutely.
All right, people also waive their right. Preliminary examination having been waived, defendant bound over to circuit court on the single count.
Thank you, Your Honor. We acknowledge receipt of information, waive its reading in the record. My client was sending. Actually, I think he needs to sign that waiver. I didn't know to sign it.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30.
All right, that's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue about?
Yes.
Your Honor, my client's bond is currently set, I believe, at 10,000 cash or surety.
It's 5,000 personal recognizance. Unless he did something.
That got revoked, yeah.
What?
But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst people.
Ah, yes. Yes, I do recall. Yeah. Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up and my client was coming off competency issues.
What?
He's coming off competency issues.
I got a lot of people that are coming off competency issues that don't spit in my courtroom.
Well, Your Honor,
On people.
he is very truly sorry for that. And he would like the court to know that.
I would like
Again,
to offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really odd for me to have done something like that.
Really quickly, Your Honor.
Why?
Well, if I say why, then I will need to approach. Approaching things.
I can just say no and it wouldn't matter, right? Yes, you may approach.
go ahead. Okay. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a person. We'd be happy if the court would consider $1,000 cash or surety, but he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have I had to stop court, come in, clean up after you. Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it ever.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlon, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
Well, that took a turn. This hearing was a classic mix of administrative cleanups, last-minute requests, and one moment that really hit the law talk with Mike trifecta odd, uncomfortable, and strangely compelling. Let's dive in. Carl. Murray started us off with a simple request. His team wanted to adjourn his matter to align with another case already scheduled for the 22nd. Clean, efficient, and cooperative. The court agreed, and bond continued. Next came Thomas Ellis. His counsel explained that while Ellis had completed a screening for 14B, they still needed a letter from his doctor to move forward. The judge granted the adjournment to August 7th. Pretty standard stuff, well prepared, no friction, and then came Sean Newton. Now, Mr. Newton's case already had a bit of momentum behind it. Counsel mentioned they were submitting a referral for drug court, and before the judge could fully confirm a waiver to the preliminary exam was already signed and in hand, Mr. Newton himself chimed in, volunteering that he just wanted to plead guilty and get out of here. It was maybe a little too much information, but hey, he was being honest. What followed was a moment that will probably stick with the court for a while. You could feel the tension shift when the topic of bond came up. The judge recalled vividly that Mr. Newton had previously caused a disruption in court involving what was delicately referred to as saliva distribution. Translation: he spit, and not in the metaphorical sense. Counsel stepped in quickly, framing it as a moment of instability tied to prior competency issues. Mr. Newton, much calmer than during the prior incident, expressed deep regret, apologizing sincerely and calling the act uncharacteristic. It was really odd for me to have done something like that, he said, almost bewildered at himself. To his credit, the judge didn't slam the door on the defense's arguments. He listened, allowed counsel to approach, and acknowledged that Mr. Newton appeared to be in a better state, but he didn't mince words either. The spitting episode, he said, put a lot of people in jeopardy, required court cleanup, disrupted proceedings, and blocked access to parts of the courtroom. In the judge's eyes, it was clearly intentional, and that wasn't something he was willing to overlook. The bond reduction request was denied. For now, Mr. Newton will remain where he is, with another opportunity maybe awaiting him at circuit court under Judge Conlon. All in all, the hearing showed the court's willingness to exercise both compassion and consequence. If you're respectful and prepared, you'll get a fair shot. But if you spit in the courtroom, you're going to need more than just an apology. You'll need time and a compelling reason to show you've really changed if you found this. Hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.